appeal in the matter of Crabb and others TUI Airways Limited.
Yes.
Good morning. I represent the appellants in this matter, along with my learned junior, Mr. Selwood, who sits behind me. For the respondent, Mr. Williams KC, who's leading Mr. Edge.
Thank you.
There is one housekeeping matter, if I may, in relation to the authorities bundle. It's simply that at tabs 31 and 32, the documents have been put
Which
in
bundle is 31 and 30?
It's the authorities bundle.
Yeah, but there's two authorities bundles.
I'm sorry, I did not realise that.
And whoever's put the bundles together has not put the numbers on the back saying which tabs are in which is always
I apologise for that.
It's number 2.
It'll be the end. Yes, it'll be number 2 because it's the last documents.
Right, thanks.
Yes.
So, document that's at paragraph 32 is in effect the document should be at 31 and vice versa. So apologies for that.
Sorry, they're just mislabeled.
Either misplaced or mislabeled.
Okay.
Yes.
Are you asked us to, assuming you're not asked us to change the
Well, I just put a little arrow like that to indicate that they're in the wrong place. So
Okay.
that might be the easiest way of dealing with it.
Thanks.
Thank you.
Yes.
I'm grateful. In terms of timetable, if I may address that first, I propose to take the majority of today, and I'm going to be addressing on grounds 1 to 4, and then sitting behind me, Mr. Selwood is going to be addressing on grounds 5 to 7, and then tomorrow, Mr. Williams Casey will be addressing you on behalf of respondents for the whole of the response.
Right.
Is that
Sounds quite a comfortable timetable. I mean, it's quite. Well, should we see how we go?
yes? I'm grateful.
I would have thought it might be possible to do it slightly more quickly than that.
It may well be,
Yeah.
and I'm sure we'll speed up as we go along.
Yes.
I'm certainly, in terms of my thoughts in relation to my submissions, round 1 is obviously going to take the most of my time.
Yes.
Round 2 is much shorter, and then grounds 3 and 4 again reasonably short.
But grounds 1 to 3 certainly are really all just different ways of putting the same point, are they?
Yes.
4 2 really.
Yes, in a way, yes. It's just attacking different points made by the judge. And then ground 4.
But all to the same effect.
Yes, which is the proper interpretation of clause.
Yes.
Paragraph 5.1.
Yes.
If I may, what I intend to do is to run through sort of a background to where we are and then move on to the grounds to give you some context. Now, these points are essentially set out in the judge's judgment, which I will summarise briefly. You will have seen that there have been permanent health insurance for pilots since around about 1974. That's certainly the first document that could be traced back to. The right to have income protection was provided in a collective agreement. The relevant collective agreement is the 2008 Memorandum of Agreement, and that provided a bare contractual right to income protection. And just to put that, so you have it in front of you, that is in the supplementary bundle at tabs 24 to 33.
Which page is
It's page 28, and it's paragraph 10. And it's the second paragraph of paragraph 10. It says the company maintained a PHI policy for pilots. Details are available from the pensions administrator. So that is essentially the bare contractual right in the memorandum of agreement. And you pick up there, it says details available from the pensions administrator. It was understood that that was, in effect, actually a pilot manager. That was the person that provided the details. And the details of the right, the PHI policy, were provided in handbooks. I'll come to this in a little bit more detail in due course, but the various handbooks were prepared by TUI for all intents and purposes and then provided to pilots. and it is that which provided the details of the benefits that pilots were entitled to. Very similar wording has essentially been used since around about 1983 in relation to the right to amend or discontinue. But of course we are focusing on two relevant handbooks for the purpose of this appeal, 2011 and 2015. The majority of the appellant's entitlement to benefits crystallised after the 2015 handbook was introduced. And it was this handbook that was the focus in the High Court. However, they're in similar terms. Again, briefly.
Hang on 1 second, sorry. So sorry.
Of course. Picking up then on what the judge found in relation to the handbook, and I'm going to turn to that handbook in a moment. The judge found that paragraphs 2.1, 3.1, 5.6 and 5.1 were contractual terms, save that there was a carve-out of the phrase "or if higher SPA" for pilots. And that carve-out is what's dealt with in grounds 5 to 7. And that is, you can see that in paragraph 309 of the judgment.
Carve out the right word? You just found it didn't mean what it appeared to say?
Yes.
Yeah. I'm sorry, I'm being slow. Could you just give me the paragraph numbers again? I know that.
So the paragraph number where it's in the judgment is 309, and the paragraphs themselves are paragraphs 2.1,
Yeah.
3.1, 4.6 and 5.1. So then turning, if I may, to the 2015 handbook, that is also in the supplemental bundle and it starts at page 51. And given that it's a key document, I'm going to spend a little time now going through it, if I may. As I've already intimated, this was a guide for the pilots to understand what their rights were. And I submit it's not a complexly worded document. You can see at the first page, page 51, the title. It refers to the TUI Travel Healthcare Trust, and the plan name is UK Permanent Health Insurance Plan. And it's got membership information, what you need to know.
Just as I'm nosy, what does Travel Healthcare Trust mean?
As I understand it, they are the ones who effectively implemented the plan in practice.
I thought TUI was a travel company, not a healthcare trust.
Yes, I think this is, I'm happy to be corrected, but I think this is a subsidiary, I don't know if it's a separate company organisation that ran it effectively. If I come on, you'll see
It doesn't matter, it's just puzzle.
Yeah.
Sorry.
Of course. And then if you don't necessarily need to turn to the next page, but that's the contents. The next important page, I say, is page 53. And this provides the context to what the handbook is effectively hoping to achieve. And you see that in the first paragraph, for the word 1 introduction, that it's a permanent health insurance plan managed on behalf of your company by TUI Travel Healthcare Limited. I think that might answer your question. I think that must be what the trust is. We've arranged for the plan to be insured by a leading insurer. Under the introduction, they ask the question, what is a permanent health insurance plan? This gives you some indication of what the intent is and what the permanent health insurance plan means. It talks about the importance of value of this is often not fully appreciated until a claim needs to be made, when the financial and emotional burden that insurance helps to relieve is then realised. So it's picking up that this fills a void where a pilot becomes unwell and helps them with the burden of that. It then picks up in the next paragraph that starts loss or reduction. That loss or reduction income because of extended illness or injury would be of serious concern to you and your family. And then it talks about the provision of benefits by the state not being adequate. The next sentence talks about the company have established a permanent health insurance plan which is managed by TUI Healthcare Limited and so forth. The cover provided under the plan is designed to help provide financial protection for you and your family if you are unfortunate enough to become unable to continue working for your company in your current capacity or in any alternative capacity agreed with your company for an extended period because of incapacity. So, what to pick out from there? It shows that this is meant to be a long-term benefit. It uses the word permanent in places. I think I've read it out 4 times on this page. I'll come to the definition of plan in a moment. Paragraph 1.2, it sets out what the purpose of the handbook is, and this is important because it's about telling the pilots how the plan works and what your eligibility is. You can see that in the second paragraph. And it tells you eligibility of cover, level of cover, when and how a claim is made. If I may take you now to paragraph 2, this is the section that deals with eligibility for cover. The general eligibility is set out in the first paragraph, but I wonder if I may take you to the second and third paragraph.
Well, don't we need to notice the first line of 2.1, your eligibility is determined by your contract of employment?
Yes, of course. And I should say that the next paragraph is around being actively at work and generally what that means. The next paragraph starts, you will generally cease. This is, you generally cease to be included in the plan when you reach 65 or if higher your state pension age, or earlier if you cease to satisfy the eligibility conditions. I should say, as is common with these sorts of plans, where it says something in bold that is effectively, and starts with a capital that's defined, and I'll take some of those defined terms in a moment. If you leave the company, you will cease to be eligible for inclusion in the plan. The plan wasn't just for pilots, and you'll see in the next paragraph is a section that deals only with pilots. It states that if you're a pilot, whilst you'll be eligible to be covered under the plan until you reach age 65 or if higher your state pension age, on reaching age 60, your cover or any benefit in payment, or which may become payable, will be provided in accordance with the plan terms by your company rather than the insurer. So this is the point where TUI effectively self-insure or self-fund the difference where somebody's in claim from the age of 60 to 65 on the learned judge interpretation. We of course have this argument about state pension. But essentially, it's setting up this difference in funding. And therefore, where there's a reference to insurer, certainly for those in-claim pilots, it's obviously a reference to TUI as the company. If I can take you now to 3.1.
Isn't the last paragraph 2.1 potentially relevant?
This is about being able to obtain being actively at work, which is part of the construct, but nothing that has applied to the individual appellants in this matter.
No, but I was noticing, unless I've misread it, that it seems to contemplate going on working after age 65. But I suppose the answer is that non-pilots would be able to do that. It's pilots who have to go at 65 under civil aviation regulations. Isn't it?
Well, My lord, that's going to be addressed by Mr. Selwood, but
I don't want to run the argument as well. I just noted that that was possibly relevant to the 65 question.
yes, well, I think what it allows is if you're working for the company in a non-pilot capacity, then you can work past 65.
Yes, well, that may be the point.
Yeah.
Okay.
Yes, so then just picking up, if I may, paragraph 3.1, and again, this was found to be contractual, save for the points around higher salary, OFI or state pension age.
So, sorry, one other question.
Yes.
Forgive me for asking all these questions.
Of course.
The penultimate para under 2.1, is that the only term, certainly the only term we're concerned with, which is peculiar to pilots?
Yes, it is.
Sorry, forgive me.
Of course, so page 55 is where 3.1 is set out under the question, what is the cover? And 3.1, the question is, how much benefit would I receive and for how long? And the first part of 3.1 sets out the length of that. So let me just touch upon that because it's important. The plan aims to provide you with a regular income benefit while you remain in your company service. This benefit is designed to act as a replacement salary. It's payable until the earlier the following. And then there are 4 bullet points which set out when, under paragraph 3.1, the benefit would cease to be paid. You return to work, your incapacity ceases, you reach age 65 or higher state pension age, or if you die. I'm going to come back to that, if I may, in my submissions under ground 1. You can see that it then states benefits payable monthly in arrears and initial will be based on your salary prior to incapacity. And then the calculations are dealt with in the following paragraphs. Paragraph 3.2 deals with when you start to receive benefit. I think this is fairly standard, that the first 26 weeks of the incapacity are a deferred period. Benefit isn't paid, but it's paid from that 26-week period, obviously, if you're deemed eligible. And that's set out on the next page, at page 56. If you meet the insured definition of capacity, and the medical evidence obtained by the insurer supports this, you'll be eligible to receive benefit from the plan. And paragraph 3.3, which is the question, how do I qualify for benefit, simply says that again, which is that you need to meet the definition of incapacity. Turning then to page 57, this is claiming for benefit. It obviously is a table showing you how a claim for benefit is made. None of that I submit is particularly relevant for the appeal, but it is there. The next important part is obviously the key, paragraph 5.1. It's at page 59. Under the title, Additional Information. And the question is, can the plan be altered or discontinued? I'll ask you just to read that, because obviously it's going to be addressed in fairly lengthy detail, by both myself and Mr. Williams. Glossary or the definition sections at page 60, section 6. I just want to, if I may, take you to definitions that I say are relevant. First of all, incapacity, which is the 5th bullet point down. You'll see that there's 2 different definitions which apply depending on whether it's the first 12 months or after 12 months. And that's to do with the way that the benefit was ultimately calculated, to do with proportionate benefit.
So captains, first officers and second officers, that's the technical description of what we're calling pilots.
Yes.
Yeah.
Thank you. And then, so section A is the bit that is relevant to us, section B is all other eligible members. And then the other point I want to take you to is you'll have picked up, undoubtedly, that the permanent health insurance is referred to as the plan throughout this document, and the definition for that is provided at page 61 in the 2nd bullet point. Where it refers to permanent health insurance, brackets PHI, brackets plan. This is a plan established by your company, which is managed by the plan manager, in order to provide you with regular payments if you are unable to continue working for your company in your current capacity or in any alternative capacity agreed for an extended period because of incapacity. That's the definition of the plan. And of course that's relevant because, amongst other things, paragraph 5.1 refers to the plan that's in it.
And I see, I haven't really focused on exactly how this works. AXA are not the insurers, they're just the administrators.
Yes.
So who are the insurers?
L&G.
Yes. Odd arrangement, but perhaps not odd at all. You'd expect the insurer also to be the administrator, but apparently not.
Yeah. And I mean, I think it's obviously at various points I suspect there was different insurers that were providing
Yes, well, there you are.
insurance contract. But I think at the relevant point anyway, as I understand it, was L&G.
Sorry, you're probably coming to this, but
No.
just since I've asked the question.
Yes.
Somewhere behind all this, but we've not seen it, is an insurance policy.
Yes, there is.
Of which the pilots are members.
They're not members.
Or members is the wrong word. Well, are they beneficiaries of the policy? That,
Yes.
If we looked at it, it would presumably identify who the beneficiaries were and give rights to the beneficiaries.
I'm not sure that's quite right. As I understand it, the policy is between TUI and L&G. It was not provided to pilots. It was provided at some point after disclosure. So it was in front of the learned judge. But it wasn't, as I said, contemporaneously provided.
Yeah, but I suppose test it this. I just want to get this clear in my head, just as background.
Yes.
Suppose there was a failure to pay a claim. Who would the defendant be?
TUI. That's with whom the contractual right that sits. So the pilot and TUI are in a contractual relationship for TUI to provide the right set out in the handbook, as per the findings. So the paragraphs that I took you to at the beginning.
What would happen if the insurer didn't agree that the claim was a good claim, but TUI thought it was? TUI would be contractually liable and would have to third party the part 20 to be old-fashioned, to be modern, the insurer.
Yes, that would be the construct.
So in fact, what is being insured is TUI's liability to the pilots.
That's correct.
Even though, if you go back to 3, it's the insurer who decides whether or not medical evidence is such as to establish incapacity.
Yes, save that obviously there are circumstances, which I'll come on to, where if there is a pilot who's in claim over 60 or makes a claim at 60 plus, that is done by TUI.
I understand that. There's a change then. But this is, so as my lord is saying, that what would happen if the insurer said, no, we're not satisfied by this medical evidence?
Well, two things would flow. Firstly, they wouldn't be satisfying the definition of incapacity within the handbook itself, so they wouldn't be entitled to the benefit.
But what was it, there was an issue about that?
Then, so I think often the case, the company would challenge the insurer on behalf of the
I see.
pilot. And I think that's generally how it happens. Often there might be an appeal put in by TUI on behalf of the pilot, but it does not give the pilot direct rights against the insurer.
And we have no idea what the insurer's obligations are under the insurance.
That's, well...
So in other words, once a claim is established, do the insurers accept responsibility for payment of it throughout its throughout the period of the incapacity?
One would assume so, but that again is ultimately a matter between TUI and the insurer. The pilot has no insight into the underlying policy, and therefore would not be able to, and has no direct contractual relationship with the insurer.
So what's the difference that so much attention has been spilt on? From the pilot's point of view, the fact that TUI doesn't have an insurance policy after 60 is irrelevant.
Well, from our perspective, we say the rights are exactly the same, whether or not you're pre or post.
So why was anyone bothered?
Well, as I understand it...
why was anyone bothered to put it in the handbook? It's completely irrelevant, isn't it?
Yeah, I mean, I think it's for information purposes.
Well, it's not even relevant information.
Well...
because the insurer, the company, says your cover will be provided in accordance with the plan terms by your company. So it's effectively saying we'll pay you exactly what the plan says you're entitled to have, and it'll come from us rather than from the insurer.
But from the pilot's perspective, it makes no difference whom is underlying the funding or providing funding, because they're paid through the payroll every month, and it doesn't matter whether or not it's TUI self-insuring or self-funding, or it's the insurer. The payment comes to them exactly the same way, which I think, my lord, is the point you're making.
Well, I suppose if TUI went into liquidation, it might make a difference, might it? In other words, if the insurers had an obligation to go on paying, I don't know enough about insolvency to know whether that is whether the beneficiary would be entitled to the monies paid by the insurers directly.
And my lord, I'm not sure I know the answer to that, but it is an ongoing entitlement because, of course, incapacity can change. So, which is...
Incapacity?
Incapacity can change. Somebody can become incapacitated, can then go back to work. So, which is why TUI has the right, obviously, to make sure that person continues to be incapacitated under the handbook.
Yes.
And therefore, as a consequence, it's not as if you could get a lump sum from the insurer when as a consequence to sort of fund yourself.
No, I'm just thinking there might be a difference. It might be relevant for the pilot to know that it's the company's obligation after the age of 60. Because I don't know, but the situation might be different in terms of recovery, because it would depend on the continuing existence of the company.
My lord,
the insurer has, if the claim has arisen, then, as you said, one might anticipate that the insurer will have an obligation to continue to pay the benefits due under the plan for so long as the incapacity continues.
My lord, I'm not certain about that. It seems to me that it might be wrong, because it's, again, going back to that primary position that the contract is between TUI and the insurer.
Okay.
So unless there's a way around that, which is not certain at all to me, and I'll deal with this in due course, it seems to me that it would be TUI that would have to be obtaining that funding from the insurer, not the pilot. The pilot can't do that. It's not. They don't.
I think someone.
My learning unit says 5.5 might be of assistance on this. Yes, it's the second paragraph.
Yes.
So perhaps the change affecting your company, my lord, is becoming liquidated.
The insurer has to start paying the benefit direct to you. Yes, okay.
Hang on 1 second. Don't quite understand what that means. The first sentence sorry, it's may just show my ignorance, but the first sentence seems counter in as the parties are legal as the plan's a legal contract involving the plan manager, your company, and the insurer. So far, i.e. not including you. Mm-hmm. Under the contracts of, well, there's some odd commas here, but under the Contracts Rights of Third Parties Act 1999, you do not have any legal rights, which means you're not involved. Where you don't have any legal rights, just pause there. I'd have thought the effect of the 1999 Act was that you did have legal rights. Is that just an inept way of saying that this is meant to express a contrary intention? Which the 1999 Act, I think, if I remember rightly, says that you A40 your right. Sorry, forget the Latin. The starting point is that you that privity. If you are a beneficiary of a contract under the 1999 Act, you can sue under it. Privity of contract is abolished. But it says you can, if it is made clear by express terms between the actual parties that they don't intend the beneficiary to have legal rights, they can say so. I think that's right, isn't it?
My lord, I'm going to have to check this in a short break, if I may, to make sure I don't say anything that's wrong.
Right, but I mean, this is just right. At the moment, I don't quite understand what's being said there. But certainly it starts by saying something which is slightly contrary to what you've been saying to us. Because the parties to the contract, which the plan is, as the plan manager, your company, and the insurer, then you don't have any rights under the plan. Clearly, the intention was that someone would pay you. I'm just not sure who. Think about it.
Yes,
and probably it doesn't matter at all. One just likes to feel clear ground under one's feet as to how this was meant to work in a case where there'd been no problem.
Well, I think I will, if I may, take a pause on that and come back to make sure that...
This wasn't an issue before the judge?
No, it was not. And of course, in relation to what's set out about it being a legal contract, of course, the judge has found that it was in fact a legal contract.
Yes, but who are the parties to it?
Between the claimant... Yes.
Clearly, there is, subject to what 5.1 says, which is what the whole case is about, there is a legal contract. I'm just not quite sure how that marries with the insurance contract.
Well, our position is simply
is this just a contract with your employer, and they luckily have a insurance company. They've chosen to have an insurance company to fund them, and also to do some of the boring work of administration. Or is it actually a contract which gives them rights against the insurer? You could have a scheme which said, we will pay a premium to an insurance company, under which the insurance company will pay you benefits. But you're saying this isn't such a case.
Well, my lord, I think our primary position is that it is a contract between the employer and the employee, and what happens in relation to TUI deciding whether or not they are or aren't going to insure the risk that they have because of that contract between employer and employee is in some ways irrelevant.
Mm-hmm. Okay, no, that's what I thought you were saying, but I just wanted to see how that fitted with what appeared at 5.5. Sorry, I'm taking too much. I just wanted to understand this. At some point, somebody will tell us.
Yeah, of course. My lord and lady, I think I've got through the important parts of the handbook, but I just wanted to take you to just the judgment that's relevant to one particular point around this, which is at page 146 of the core bundle.
Which page did you say?
Page 146, and it's paragraph 244. You'll see that there's reference to HB, and that's an abbreviation for handbook, and that's a reference back to the 2015 handbook. You'll see that used throughout the judgment. And what is stated is this, what I want to take you to is the second sentence. It refers back to the handbook. It was a company document signed off by TUI, even if the broker may have had some input, and the only material that was available to the pilots and other employees to explain how their eligibility might arise and how their benefit might be calculated. And then it goes on to say, in the absence of access to insurance documents, which in any event would have applied for those seeking to claim who'd passed the age of 60, an in-claim pilot who may have received a shortfall or believed that his or her benefit was not being properly calculated and who wished to legally challenge would have no other recourse than to rely upon the handbook for a statement of that benefit. And that's the structure that the judge arrived at in trying to understand the handbook in the context of there being an underlying insurance policy between TUI and insurer. For the purposes of this appeal, the relevant parts obviously to take away from this are that the handbook was effectively a company document signed off by TUI with some broker input, and it was provided by TUI and the only material available to pilots to understand what their rights might be. And that's consistent with the fact that the 2008 Memorandum of Agreement provided just a bare contractual right, and the details were provided in handbooks that effectively fell outside of collective bargaining. Picking up then...
and although that was the contractual nature of 5.1 was in issue below, it's not in issue now. It's not one of the things raised in the respondent's notice.
I'm sorry, Mona, I didn't quite...
The contractual status of 5.1 was in issue below.
Yes, no, it's agreed. Yes,
but
right.
it's not. It's no longer.
It's not being appealed.
Yeah.
So then, just there was a sea change, however, which is obviously why we're here, which is that at the end of 2019, early 2020, TUI decided to collectively bargain with BALPA to bring the PHI terms and conditions, i.e. that's what's set out in the handbook, into a collective agreement. But until then, those terms and conditions within the handbook weren't collectively agreed. And I just want to pick up on that. That is important to understand that timeline, because the respondents refer in their skeleton to the objective intention of the parties to remove the collectively agreed benefit out of collective bargaining. That's reference to the collective bargaining process. But of course, whilst the benefit at a high level was collectively agreed, the actual details weren't.
So the existence was included, but not the terms
Yes.
of the plans as described.
Yes, that's correct.
But is that a change? I mean, the 2015 handbook wasn't collectively agreed in the sense that they didn't sit down bargaining over the terms in the handbook, or did they?
No, they did not. It was.
So why is it a change in 2020?
Because in 2019, early 2020, that's when the negotiations start with BALPA in order to try to bring the actual underlying terms and conditions set out in the handbook into a collective agreement. So that's the sea change at the end of
Yes, I see.
2019.
I may have misunderstood what you were saying. Yes, I see.
So then, if I can just then pick up on the events after 2019, around 2019, early 2020, TUI and BOLPA agreed to enter into negotiations to agree a new form of income protection. That failed, but there are two important points to take away which are relevant, I submit to the appeal. Firstly, TUI, in anticipation of a collective agreement being agreed, decided not to renew the underlying insurance policy through which they had insured the risk of PHI benefits being paid out. This meant from January 2020, pilots falling ill and claiming benefits under the handbook were paid by TUI, whatever their age. And you might have picked up on the reference to the GIP gappers in the judgment, and that was a phrase used to describe that group of in-claim pilots. The in-claim pilots...
Sorry, can you just, one very basic point, which I haven't quite got my head around. You say that's for those falling ill and claiming benefit for the first time after January 2020. Those who were already in benefit continued to be paid, well, it might be technically paid by the company, but it continued to be funded by the insurers. Is that right? Even though the policy had lapsed?
Yes, because at that point, the entitlement had crystallised.
Yes, and that goes on indefinitely, notwithstanding that the policy between TUI and the insurer, the insurer promises to pay benefits to TUI employees even, indefinitely, not just for that.
Yes,
policy
well, I think, as I understand it, under the terms of the insurance policy, it was to age 60, and then TUI picked up the difference.
Yeah, well, I'm sorry, but forget,
Yeah.
Okay, that's fine. Let me just,
yes.
I thought that must be right, but
And my lord, there's a further important point just to understand in relation to that, which is in those 2021 negotiations, the in-claim pilots, so those that were in-claim before, at the point of negotiation, they would be untouched by the changes. So their rights to benefits continued and were not going to be affected by the changes that were going to be introduced by the...
for the reason I've just clarified with you. Yeah.
Yeah, well, and because a decision was taken by TUI and BOLPA that those rights of in-claim pilots were going to be untouched.
Yeah, but TUI wouldn't mind that because that's all covered by premiums they paid in the past. It's no skin off their nose to go on paying them because the insurers are paying anyway, up to age 60.
Well, up to age 60, and that's the point. So there is a, as we can see, a benefit to TUI financial benefit, cutting the rights of in-claim pilots down. And that is ultimately what happened. But we say that is important in terms of just the way that TUI had addressed the in-claim pilots' rights at the point of the GIP negotiations.
Sorry, just one other question. When you get your pay slips and you're in claim, it just shows up as ordinary salary, does it?
It states PHI on the payslip.
But it's a payment from your insurer. Sorry,
No.
from your employer.
Yes.
Yes, but
And
with
attached.
a label PHI.
Yes.
Yeah.
What happens next is COVID, and therefore these negotiations are put on hold. And you'll have seen in the bundle there are COVID agreements. Effectively, those are agreements to cut general salary of pilots. But again, those in claims salary under the handbook were protected, so they weren't reduced. That then moves on to the key negotiations, which ultimately resulted in the new Schedule B to the Memorandum of Agreement, and that started in mid-2021. And I'm going to, if I may ask you to turn that up, it's at page 200 of the supplementary bundle.
Do we have the memorandum of agreement itself, or only the schedule?
I believe we've just got two schedules in there.
What was the full memorandum of agreement before the judge?
I think it was, yes. I remember reading some very lengthy documents of that nature. I don't have the index.
No, okay. It probably doesn't matter. I just, again, to feel clear around this all goes back to a collective agreement made with a particular date, with certain formalities.
Yes.
We haven't got here. We've only got the schedule to it.
That's correct. And you'll see that just on that point, on page 207, there are signatures and a date. And I believe that it says the 16th of August 21 is the date.
Well, if my lord doesn't mind, I'm not asking you to produce copies for us if it's a 500-page document. I have no idea, but could you just look into the practicalities about seeing it?
Yes, of course.
Just,
yeah, it might be we can extract it from the bundle for the.
It's just as I said, repeating myself. So I have the basic building blocks. I'm sorry,
my lord. Sorry to interrupt. I'm conscious this is something that is within TUI's purview. This operates as these schedules amend the existing MOA. There's 2008 one and there's a 2018 one. So that's how it works. So the document you're talking about is the 2018 one that we've just had.
Yes, I see. But then what happens? So is there exchange of letters between the union saying we will agree Schedule B to be substituted for the previous?
That's I will need to check.
Was there a Schedule B of the 2018 agreement?
Yes, there was.
And it said something different.
Yes. What page is it?
I've obviously got it wrong. I thought there was a 2021 Memorandum of Agreement. But that's wrong.
Well, there were certainly two before the judge, 2008, 2018.
Yes, but when the big change came in, my lord and I both assumed there would be a new memorandum of agreement. But you're saying not. You're saying there was an agree to amend the previous memorandum of agreement. That agreement must still have been recorded somewhere.
Yes, and my understanding was at 20, but I will double check.
It was in what, sorry?
It's in the 2018 MOA, which is in this, which is before you.
No, but it can't be. When the 2018 memorandum, it must be across purposes. The 2018 MOA was entered into. Schedule B didn't exist. Well, there's a different Schedule B. Something happened in 2021 to introduce the PIP. And that must have been, you can't just produce a bit of paper.
No, obviously Balper and TUI agreed to put this.
Yeah, well, how did they agree? Did they write a letter to each other? Did they produce an amendment document?
I understand the point. I will find that out, my lord.
And I'd quite like to know what the previous schedule. We haven't got the previous Schedule B, or have we?
Not before you, no.
It's just, again, I'm afraid it's my own theme. I just want to understand the mechanics of how it all works. Probably at the end of the day, it won't make any difference. But if one's to be writing about this, one wants to get it right.
Leave that with me, my lord.
Sorry.
Of course, I was taking you to page 200 of the supplementary bundle, which is the Schedule B that was introduced in 2021. And therefore, we'll come and deal with this, it's obviously of import to understand what it says. If I can take you to page 2, you've got the definition section, and what I just want to take you to is the phrase legacy claimant, which is defined as somebody who's in claim under the PHI scheme, but who's not reached the age of 60 as at the date, 16th of August. And then there's obviously reference to PHI, reference salary and escalated salary as well. But that's quite complex, just to note that that's there. There then is the scheme, which is set out, starting at paragraph 1. The point we say is relevant to the issues before you is at page 204, and it's paragraph 3.27, and this deals with the PHI.
Sorry, don't we need, just to get the structure of this,
Of course.
1 is sickness absence, has nothing to do with us. 2 is ground duties. 3 is pilot income protection. Isn't that relevant?
Well, yes and no, because all of the appellants were in claim, and there's a separate section that deals with them. So as I understand it,
I see.
3 is for non-in-claim pilots, so somebody who's coming anew to the...
Yes, I see. So this is of no real relevance because this group are dealt with separately.
Yes.
Yep. Okay, sorry. Yep.
Of course, and then, and so that goes all the way through to paragraph 3.27, which is the PHI to PIP transition. And just to explain what this is saying is, of course, when you turn 60 under the PHI scheme, it made no difference. TUI continued to pay you. What happened with the new scheme is they sought to cut down your entitlement
After 60.
after 60 significantly. And that is what the PHI to PIP transition...
I'm sorry, just to be really boring about this, but make sure I'm not muddling myself. They couldn't and didn't attempt to change the position before 60 because that was already covered by the PHI, that was crystallised.
Well, that's obviously going to be an argument, but as I understand it, they could do it because, well, they said they could do it because they didn't have insurance behind it. Whereas with those over
I see.
60,
Well, no, but they did have insurance.
not
Well,
for the 60,
for the people in claim, although they cancelled the policy a couple of years earlier, I thought, as you confirmed a few minutes ago, the people who were already in claim, it wasn't a problem.
So
up to age 60.
up to age 60.
Yes.
So TUI effectively, because they had the risk being paid out by insurers, didn't try to change the in-claim pilots' benefits for those up to age 60.
Yeah, that's what I was putting to you.
Exactly.
That's the reason that they had no interest in doing that because
Exactly.
it wasn't coming out of their money.
So their financial interest lies in reducing the amount paid out for those over 60.
Yeah.
And that's what they did through this PHI to PIP transition. And they did so by reducing the amounts paid out under the pension, also in relation to something called proportionate benefit, which was up to about 50% of the benefit being paid out to those that were in claim. The structure is complex, and I don't think you need to understand it necessarily for the purpose of the opinion, although we can take you to it if you do want to understand it. The important part, I say, is 3.27, where it sets out, in accordance with section 5.1 of the PHI Handbook, a legacy...
Sorry, I'm so sorry. Which whereabouts?
On page 204, at the top of the page.
Yeah, okay.
3.27.
Yeah.
In accordance with section 5.1 of the PHI Handbook, a legacy claimant achieved escalated reference salary will continue and will therefore not be reduced. A legacy claimant will continue to receive escalated benefits. They then go on to set out the new way that PHI is going to be changed to PIP and calculated by way of benefits. 2 points to take. First of all, the phrase "in accordance with section 5.1 of the PHI Handbook" suggests recognition of the rights contained in section 5.1 in a particular second sentence. Secondly, looking at this part of Schedule B, there is no express clause that states that section 5.1 of the PHI Handbook no longer applies or has been overridden.
Well, it doesn't say use those very words, but what it provides for is something which is inconsistent with the final sentence of 5.1, isn't it?
Yes, because it changes the benefit.
Right.
So it's an odd use of word to say in accordance with section 5.1 of the PHI Handbook.
But all that's saying is that's only about legacy claimants. Legacy claimants stop being legacy claimants at the age of 60. So at the moment, I don't see anything wrong with what's said there, or anything odd.
Well, I think it's the use of in accordance with section 5.1. If the respondent's position is that they can do what they want because they're collectively bargaining, then the recognition of section 5.1 is the point I'm trying to make, which is that I submit that must mean something. And
section 5.1 is irrelevant on the respondent's case.
Yes. So
why is it there?
Why is it there? It's been acknowledged. And you're absolutely right. Obviously, they then go on to completely undermine what we say the correct reading of section 5.1 is. But it's an odd phrase, but it's important because it's otherwise completely obsolete to set that there.
Can I, at some point, because it's not set out, I don't think, anywhere in the documents, it would be helpful to understand what the underlying impact is. So it is the underlying impact only, does it only affect those those who are in claim after the age of 60? Up to the age of 60, there is no financial difference, or is there?
There was a financial difference to do with pension entitlement, but that was effectively a different box. But in terms of that underlying benefit, it stayed the same.
Right, okay.
Then just picking up on what happened next, you've seen Schedule B. The ballot was voted on the 13th of August 2021. Just in relation to that, there was no vote. There were just two options of how the new PIP structure would be. So in terms of that ballot, the pilots couldn't say they didn't want the change. And then on the 16th of August, in-claim pilots over 60 were notified by TUI they were no longer going to be paid benefits under the handbook, but according to PIP. And just to put that, you can see that at page 96 of the core bundle at paragraph 59 of the judgment.
So paragraph 59 is it?
Paragraph 59.
Thank you.
Obviously, from those pilots, there was a drastic, rapid reduction in income.
You say obviously, we'll need to explain why.
Yes.
Just so we, in a sense, it doesn't. The numbers don't matter because it's a point of principle, but I think we'd like to know actually how big the impact was. So if the judge does spell out somewhere, I didn't quite get it.
My lord, I don't think he does, but perhaps I can produce a document that would assist you with that, rather than me floating numbers in front of you. I will.
But but in big picture terms, what are the changes that had the impact?
The big picture was they removed this idea of proportionate benefit, which was about 50%, well, up to 50% of the benefit. And therefore, so somebody like the first appellant's benefit reduced by half. So it was a very significant reduction for him. And he was given the letters when they were told on the 16th of August that change was going to take place was the first time that the employer had written to them directly. And then they weren't actually told what the calculations were until about 3 weeks later.
Okay, but just I see why you want to make that point, but just so is it really just removal of proportionate benefit?
That was the key change.
Are there any other changes?
Well, there was a change to pension entitlements.
But you said that's a different matter. No.
Acceleration. Escalation.
Yes, oh, that's right, escalation of benefit. It was 5% escalation,
It's changed.
and that was linked to your salary as opposed to your benefit salary, whereas under the new scheme, it was linked to the benefit salary, which is obviously substantially less.
Yes. Thank you. So those are the two changes you make up.
Yeah.
Make the big difference.
I think that's right, yes.
And just sorry, again, to just get this clear in my head, you said a letter goes out as soon as the ballot decision is known, saying to those who are already over 60, this is the position from now on. Since then, I mean, not all the claimant group had yet reached 60,
That's correct.
but perhaps some have since then, and even if they don't, some will in due course.
Yes, and I think some have during the course of the proceedings.
During the course of the proceedings, yeah.
My Lord, I was going to move on to ground one now, unless there's anything else I can assist you with in terms of the background picture. And I wonder if that's a point, if you were to take a break in a moment, to have a break before I move on to ground one, or shall I continue on?
No, do you want a break?
No,
I think. No, do you want?
that's fine. Of
No,
course. So,
fine. Thank you.
Since I've retired, come a habit of people having a break in the middle of the morning.
yes, in some courts, yes. If I may then move on to ground one.
Standards are slipping clearly.
So, picking up on my skeleton argument, I've obviously dealt with the background, and I'm going to pick up, if I may, immediately on the judge's interpretation of paragraph or section 5.1. Obviously, the appellants fundamentally disagree with that interpretation, and I'm going to deal with that. Why? The judge interpreted paragraph 5.1 as provided a limited safeguard, and that operated only on the company's unilateral right to amend or discontinue, which was provided in the first sentence of section 5.1. So he therefore considered two things. Firstly, that first sentence in paragraph 5.1 conferred a unilateral right to TUI to modify or discontinue PHI where business or financial conditions warrant it, and that didn't include change to collective bargaining. And secondly, he linked the second sentence of paragraph 5.1, which has the words that I'll come and deal with in due course, as providing protection from only unilateral change by TUI. That's essentially the kind of nub of what the judge found. I'm going to turn to look at the authorities bundle now and just look at some of the key authorities on contractual interpretation. The first case I'd like to take you to is Investors' Compensation Scheme versus West Bromwich Building Society, which is at tab 7, page 38, starts at page 38. I think this will be the first of your authority bundles.
You can take us through all 5 of those Supreme Court cases.
I'm not going to take you to all 5.
I thought all this had been sorted out by the last one, but
Well, I'm going to tell you something. If you want me to take you straight to what I
no,
can.
sorry, it's not for me to say, but I
No,
just wanted to know what we were doing that in with.
well,
I think for the moment, stick to how you were planning to do it.
Sorry.
that I'm grateful, thank you. So, I mean, I'm not going to take long, if that helps. The key part is at page 54 of the authorities bundle, and you can see the red line there. It's simply setting out, just in terms of background, obviously this is a non-employment case involving investors who lost money backing their mortgage products and took action against their financial advisors. And at page 54 of the authorities bundle from F onwards, the House of Lords sets out the principles of contractual interpretation. And then sets out a series of propositions. I cite part of that in my skeleton argument. Of course, here I submit that, and I don't think this is in dispute because my learned friend has referred to it in his skeleton argument, but it's looking at the reasonable person having all the background knowledge which would reasonably be available to the parties in the situation in which they were at the time of the contract. And of course, we submit that that's the 2015 handbook. I'm not going to take you to either Chartbook or Rainy Sky. Both of those are cited in my skeleton for propositions around the language and determining that something has gone wrong with the language used in a contract. But I do want to take you to Arnold versus Britain and versus Capita. So Arnold versus Britain is at tab 14, page 185. Of the authorities bundle. And again,
Which page, sorry?
It's page 185 is where it starts. And again, it's a non-employment case. It's interpreting the paragraphs in the lease relating to payment of service charges. And the facts aren't particularly relevant to this matter. The leading judgment is given by Lord Newburgh of Abbotsbury, and if I could just take you to page 193 and section from paragraph 15 onwards. I think this is helpful because the learned judge does two things. Paragraph 15 sets out, when you're looking at the meaning, how do you assess it. So you look at the natural ordinary meaning of the clause, any other relevant provisions, the overall purpose of the clause and the, in that case, the lease, but I submit here the handbook, the facts and circumstances known or assumed by the parties at the time that the contract was executed, commercial common sense, but disregarding, the subjective evidence of any party's intentions. And those I submit are obviously of import when looking here. He goes on to develop 7 factors from paragraph 16 onwards. I just want to draw out, if I may, 3 of those factors. A paragraph 19 referred to this idea of commercial common sense, and I just want to put that in context, and this refers back to Chartbook. Here, this is about the provision of permanent health insurance, and that is obviously a benefit provided by employers to protect their employees if they get unwell. I think we see that very much from the wording of the handbook itself. And it was that structure that has been adopted since at least 1983. And there wasn't, as far as I'm aware, nothing in front of the judge that it was imprudent or otherwise for the construction adopted by the claimant, for that to be a proper construction, i.e. that this was a structure that had been adopted since at least 1983. The commercial aims, I say here, are reflecting the impact of stripping long-term benefits on short notice from employees who are in claim.
It's contrary to commercial common sense to do what?
Are reflecting the impact of stripping long-term benefits on short notice from employees who are in claim. That's the sort of commercial context. The second point is in paragraph 21, which is in relation to the facts known at the time of the contract to both parties, just picking up on that. As at 2015, as I've already stated, the benefits within the handbook were not found to be collectively bargained. And of course, as at 2015, the parties wouldn't have known that in due course they might come into collective bargaining. My lord, if I then may take you to Wood versus Capital, which is obviously the most recent, as you rightly indicate. of the cases. And if I can take you to tab 15. Sorry, my learner junior rightly pointed out I didn't take you to paragraph 18 of Arnold, which is around understanding, looking at the natural meaning of the words, and that is important. I take you to that. It's page 194. This is around understanding and looking at the words. What is essentially said there is that the clearer the natural meaning of the words used, the more difficult it is to justify departing from it. And it's not really for the court to embark in an exercise of construction, drafting infelicities in order to depart from the natural meaning of the words used. Obviously, the essentially relevant words in this matter are those contained in paragraph 5.1, in particular the second paragraph.
Second sentence.
Second sentence, apologies. Second sentence. And of course, our fundamental or underlying submission is that the learned judge fell into error when he, in fact, ignored the natural meaning of the words "any change" and found there needed to be an express exclusion of changes that come through collective bargaining. So then, if I may take you to Wood versus Capita, which I said, which is at tab 15 and page 229. Again, it's not an employment case and it involved the interpretation of an indemnity clause. The relevant parts I'd like to take you to start at page 234. Towards the bottom of the page. And in fact, run through page 236. If I can pick up at paragraph 10, again, this is about looking at what the court's task is, ascertain the objective meaning of the language which the parties have chosen to express their agreement. It's not a literalist exercise focused solely on a parsing of the wording of a particular clause, but that the court must consider the contract as a whole, and depending on the nature, formality and quality of drafting the contract, give more or less weight to elements of the wider context in reaching the view as to that objective meaning. And again, it won't surprise you to understand that we say that's not what the learned judge did. I may also pick up at a point at paragraph 13, which is around the balance between textualism and contextualism. They're not in conflict, and it's about looking at both. But of course, factors that are important might be, for instance, where the contract is informal, brevity, or in the absence of skilled professional advisors. Of course, certainly from the appellant's perspective, they didn't have professional advisors. This was a document in plain English to explain by TUI what their benefits were. I'm going to take you to a further case, if I may, which is dealing with a slightly different point by the Court of Appeal. This is the case of Amdocs. And I believe it's probably going to be in your second appeal bundle. I'm not sure if you...
What tab is it?
Yes, it's tab 21, page 472. Amdocs Systems Group versus Laing. This is an employment case, and I'm going to just deal with the facts because of their import. So this starts at page 473. the case was about whether the employee was entitled to an annual increase of 5% in payment under a salary protection plan or health insurance, similar, therefore, a plan similar to what we're looking at today. The terms are set out in paragraph 2, and towards the bottom of page 473 is the section income protection sickness payments, and it sets out what those rights were. And it refers to a summary of benefits at the bottom of that page. Paragraph 3 has an offer letter that contains a summary of benefits. The individuals will cease to be included in the scheme at age 60 on ceasing to satisfy the eligibility conditions. And the section that was in dispute is the fourth paragraph from the bottom that starts after benefits have been paid continuously for 52 weeks. The benefit will increase by 5% every year until you return to work. And in this way, your benefits have a degree of protection from inflation. And then there were then some additional documents that are set out in paragraph 4. The claimant accepted the offer of employment in 2000. Sorry, and then he in 2007 went on to the scheme. Go to paragraph 14, which is at page 480. There's a change, and he signed the new document 2007. By 2008, the escalator of 5% had been removed from the scheme by the employer.
Where do we see that?
Paragraph 24. So, effectively, what is set out paragraph 24 is when the claimant was told about it, and he's told that this was after the policy removed the escalation in October 2008. So he was told he didn't have escalation in his benefits payout.
That's the policy between Amdocs and Sun Life, is it?
I believe the reference is to the policy between the employee and the employer.
Policy?
No, sorry, I stand corrected. I think you're right. I think that's correct. It is
Okay.
the policy rather than the scheme. Paragraph 22 is him receiving a letter from Standard Life regarding the pension plan. That's the point. So Standard Life's obviously the insurer.
Oh, I see. Sorry, I said no. Sun Life. I was saying because if you meant, well, I said Sun Life because that's what it's referred to at 3. Page 474. Company of establishing income protection scheme with Sun Life Financial of Canada. Sorry, again, this may not matter. I just don't.
It may be that.
Confused.
Yes, of course. It may be that the insurer or the person executing insurance changed to Standard Life, because that's definitely who wrote to them.
The Standard Life was about his pension, wasn't it?
Yes, but that's the point when he realised he wasn't being paid.
Oh, okay. Well, it probably doesn't matter.
Yeah.
Come back to it if we have to.
In any event, the issue of that was being disputed. You can see at paragraph 25. He brings a claim for unlawful deduction of wages, and the claimant argued he was entitled to the 5% annual escalation on the basis of the 3 documents that were sent to him on the 25th of July 2003. So those are the documents we looked at the beginning. And Amdocs accepted the income protection insurance policy in force for the period from the date of commencement of the claimant's employment to the 30th of September 2008, had specified that benefits payable under the income protection scheme would be increased by 5% every year. But the company's case was that the claimant had no such entitlement because it had been lawfully removed in 2008, and that was before the claimant applied for benefits under the income protection scheme. So that's the issue. And just in terms of what the claimant knew, if I could take you to paragraph 31, this is the tribunal finding. He's probably much more coherent than I've tried to do, set out what's happened. But in paragraph 31, the tribunal accepts that the claimant's evidence that he had not been made aware of the removal of the escalation rate from the income protection scheme before engaging in correspondence with the respondents about the income protection scheme in 2016. And then paragraph 33 is where, again, they repeat what the tribunal found in relation to having a clear contractual intention of the parties to bestow upon the claimant as a permanent employee the benefit of the income protection scheme described in the offer letter and sum of benefits, which included that 5% escalation rate. Then, if I may pick up at paragraph 57, which is page 493. It might assist just to have to read paragraph 54 as well, which refers back to what the handbook is and terms set out in that summary of benefits letter. Paragraph 57, just in terms of that interrelationship between policy with the insurance and the scheme between the employer and employee, they deal with the issue around what the underlying insurance policy actually provided. And they say there's something in insurance documents listed in July 2003 which contradicted the express promise in a contractual document. This should have been brought expressly and unambiguously to the claimant's attention. And the Court of Appeal agreed with what the EAT had found in relation to that and referred back to paragraph 67 to 69 of his judgment. And that, I just want to put that in context, was set out at paragraph 46 of his judgment. So we have to go back just to see what is said there. And it starts on page 487 of the bundle. So, having commented on what Mr. Albert looked at, the EAT judge Albert looked at in relation to the authorities, he then summarised the effect of those cases as follows, and that's where you get the 67 to 69 being adopted by the Court of Appeal. Again, I'd ask you to read those. The most important part is paragraph 69. The point that I want to draw out from this is that if there's going to be a limitation of the employer's exposure, that should be unambiguously and expressly communicated to the employee, that there could be no doubt about it. And that should be done in a document we submit, provided to the employee or drawn to their attention. That's essentially what's being set out in paragraph 69. That's relevant because of the way that we submit the respondents and the learned judge come to their conclusions on the second sentence of paragraph 5.1. That's the legal framework, so I'm going to now move on to the interpretation, and I'm going to do that in 3 stages. First of all, I'm going to look at the ordinary natural meaning of the words in paragraph 5.1, and then I'm going to look at the context. and then after that I'm going to pick up some particular points that are relevant to submit to this issue. So first of all, picking up on what is the ordinary natural meaning of words. And I'd ask you if to have in front of you paragraph 5.1, which is in actually both the core bundle and the supplemental bundle. I'll ask you to look at it in the supplemental bundle because that's where I've taken it to you already. It's page 59. So the second sentence, we submit simply any change means what any change would, looking at it, mean. It incorporates all changes that can be made. And that must include change that takes place through the mechanism of collective bargaining.
Why do you say it must? Surely you've got to read it with the previous sentence.
Well, I'm going to deal with that, my lord, now, because that's my next point. The learned judge found that you had to read the first sentence with the second sentence, and I submit that is wrong, and I'll make good that submission now. Any change is a broad term. It does not refer back to the first sentence. I submit it's independent of the first sentence. And I make that submission because if you look at that second sentence, if the writer of this document had wanted any change to refer back to the first sentence, they would simply have used the word any such change in that first reference to any change. So it would read like this: benefit already being paid at the date of any such change will continue and will therefore not be affected. There'd be no need to refer to any such change in the second part of that, or the end part of that sentence. That would be a linking, a way to link the two words. There is nothing in that second sentence that links it back to the concept dealt with in the first sentence. The fact that any such change is used in the last part of the second sentence is particularly interesting because it shows that TUI had in mind the need for an ability to link back to previous words in a document. And if that had been intended to be the reading of the second sentence, that word such would have been in the first part of the sentence, but it wasn't. And therefore, I submit there is no link between the first and the second sentence in paragraph 5.1.
What role is the word such playing in the second sentence then?
In the second sentence, it's linking it back to the first use of any change.
But that's redundant, isn't it? Because on your construction, any change means any change. It's unnecessary,
It just repeats that it won't be affected by any such change. It is potentially repetitive, but it's not redundant because it makes it clear by linking it back to that use of the first any change. I submit a self-contained sentence.
Absolutely.
And that this is so, I submit, is the need for the word such to link it. I submit is actually clear from the respondent's skeleton argument itself. In the core bundle at page 51, and perhaps I just read it out rather than make you turn it up, at paragraph 16, they say this about the link. They say the second sentence of the provision needs to be read in the context of the first sentence In other words, the second sentence sets out the agreed limited effect of the exercise of that discretion, which is that such changes would not apply to in-claim pilots who are already receiving the benefit of PHI. So even in writing their paragraph, they've had to insert the word such to be able to link the second sentence to the first sentence. And that's because the word such is necessary to do that. If I may, while we're looking at the wording, I'm going to look at the point that...
Well, you might say that grammatically, not having such, if you just deleted such, it makes a bit of a nonsense to the second sentence, saying benefit already being paid at the date of any change will not be affected by any change. It makes more grammatical sense to have such when you're using any change again, rather than just simply repeating any change.
Yes, certainly in the context of that, and Elisabeth being self-contained, when you read it in that way, it is a self-contained sentence. The word such change refers back to any change.
Yes. But what I was saying is, if you deleted that, the sentence is rather clunky, whereas your submission is inserting such, makes it clear that it's referring back to the any change.
Yes, and if that referral back was intended, that word such would be in the first part of any such change and not in the second part. Well, as I was about to move on to the point the judge made, where he said that he talked about that there should be words, and this is paragraph 262 of his judgment. If you look at that, it's page 151.
So which paragraph of the judgment?
It's 262.
262.
And it's page 151 of the core bundle. What the judge says is in the second part of that paragraph. He says, if the provision of paragraph 5.1, furthermore, which purported to protect benefits which were being paid both pre and post 60, had been intended to provide a carve-out from any future collective agreements, thus nullifying the provision in the contracts of employment which allowed for incorporation, specific wording to this effect might reasonably have been expected. And the judge doesn't say what that wording would look like. I've tried to understand what it might look like to see or to assist the court. Again, picking up on the second sentence of paragraph 5.1, it would need to read something along these lines. Benefit already being paid at the
So
date...
is this in your skeleton?
No, it's not in my skeleton.
Okay.
I'm apologies.
No, it doesn't matter at all. No, I just wanted to
I was thinking of this as...
No, I wasn't criticising. I just wanted to know whether I needed to note it down. Yeah.
Yeah, so the first part of the second sentence remains the same, but then you add these words after the any such change, including change introduced through the collective bargaining process. So that's what the judge is saying, is that if you were going to ensure that that change to the collective bargaining was protected by the second sentence of paragraph 5.1, needed to be expressly stated, or should reasonably be expressly stated. And that's what I came up with anyway. I'm sure you'll have a far more erudite version, but in any event, it's adding in words into a sentence and narrowing the scope of the reference to change. We submit change necessarily incorporates change introduced through the collective bargaining process. So our submission would be those words, in fact, are obsolete or redundant on our interpretation. two further points I'd like to make in relation to that.
Well, on your submission, any change means any change,
That's
including or however effected.
that's correct. And I just want to make two further points on that, which is just picking up on the words of any change and then looking at express wording that I submit actually might be required if to give the judge's intent or the lack of express wording. So first of all, just looking again back to any change, I submit this is a completely unambiguous term, and just repeating a point, it necessarily encompasses change through collective bargaining. And what is expected or should be adopted is essentially a plain reading of what that ordinary and natural meaning of those words are. So there's no need to specify the type of change that would be covered by that phrase. And just referring back again to Arnold versus Britain, the clearer the natural meaning of the words used, the more difficult it is to justify departing from it. And the judge essentially fell into error because he has embarked in an exercise of construction, drafting, and felicities when the answer was plainly in front of him. And in fact, what we say at paragraph 12 of our skeleton is that the judge was wrong to make that conclusion around having a sort of specific carve-out for collective bargaining. And I want to play an if I may, of that proposition, the case of Tesco, Usdor versus Tesco, which is at tab 24.
Hold on, you want us to go to that?
I do. Yes, thank you.
Which bundle is it in?
I think it'll be the second authority bundle. Again, this is an employment case, and just briefly in terms of the facts, if I may, Tesco and Usdor are being the relevant union, negotiated retained pay as an incentive for staff to relocate to a different Tesco site, and that was agreed by way of a collective agreement that was incorporated into individual contracts of employment. And the relocation took place around 2007. 2 years later, the retained pay clause was agreed in a collective agreement and incorporated into individual contracts of employment in 2010. And that's recorded at page 588. Just picking up just about the five lines down is the focus of the submissions by both parties.
Sorry, which?
So page
paragraph?
588 and it's the first paragraph at A.
Thank you.
Yes, sorry, the paragraph rolls over to this page. So it's paragraph 6.
Yes.
Yet the focus of the submissions by both parties has been on interpretation of the express retained pay clause in a collective agreement that was only agreed some 2 years later in 2009 and signed on the 18th of February 2010. It was only at or shortly after that later date, that the express term became incorporated in individual contracts of employment. The best analysis of the sequence of events appears to be that while the full articulation of retained pay was not incorporated into the individual contracts until 2010, the same meaning of a retained pay applied throughout the relevant period. There's no suggestion that the meaning changed in 2010. The parties were therefore in agreement that the judicial task is to interpret the full retained pay provision, taking into account the pre-contractual material that also predated the moves in September 2007. There's a slightly clunky way that this was effectively incorporated, and there were 2 different relevant documents, but that interpretation of retained pay didn't change. That retained pay clause is set out at paragraph 17 of the judgment, page 589. It starts at page 589. And I'd ask you to read that because it's something I'm going to come back to at various points during my submissions. Just, if I may, just drawing out 2 points that arise from this clause. First of all, it doesn't expressly state that collective bargaining will or will not affect it. It's silent as to that.
Well, doesn't it? Retained pay can only be changed by mutual consent.
Well,
That must be mutual, surely, between the employee and the employer.
yes, that's correct. That's my second point. So it doesn't refer to collective bargaining. What it does refer to is only being changed by mutual consent.
Well, quite. So you wouldn't need to refer to collective bargaining.
Yes, it is a point though that is is looked at, and I'll come back to that. For the purposes of the submissions where I am now, also pulling out relevance is reference to the retained pay. This is at the top of page 590. It will remain a permanent feature of an individual's contractual eligibility subject to the following principles. So those are the principles 1, 2, 3 and 4 by which the retained pay may no longer apply.
Were these contracts subject to collective bargaining, or the effect of collective bargaining that the contracts in this case were subject to? Is it referred to anywhere?
These ones in Tesco's
Yes.
were subject to collective bargaining.
And indeed, the retained pay clause was collectively bargained.
Yes, that's correct. If I may, on this point, take you to paragraph 38, page 596.
Sorry, say it again.
Paragraph 38, page 596.
Thank you.
In fact, the paragraph starts right at the bottom of page 595. The issue became whether or not the Tesco could give notice to terminate these contracts and then rehire them on terms that didn't include the retained pay clause. And so paragraph 38, Tesco maintains that the meaning of each of these two expressed terms is clear and obvious and they function consistent with one another. Tesco submits that each affected employee's entitlement to retained pay remains a feature of their employment contract for as long as the contract lasts. But like any other entitlement under a contract requirement, is subject to Tesco's express and unqualified contractual right to terminate the contract on notice at any time Tesco's choosing. So, and then it sets out a little bit more about what Tesco says. While the retained pay would last only for as long as the existing contract lasted, and accordingly there was no inconsistency between the two express terms, that being retained pay and the right to terminate on notice. Paragraph 39, stated by Lord Barras and Lady Simler, the logical and on the face of it alarming consequence of Tesco's submission is that it would have been open to Tesco to terminate on appropriate notice the contracts of all affected employees immediately after they had relocated. And Mr. Degar Robinson case, he accepted that that was correct, but that the practical and commercial considerations, including likely industrial relations impact of such a course of action, made this a fanciful prospect. And it's noted then that may be true, but it does not obviate the objection that the interpretation favoured by Tesco is legally problematic and produces a potentially absurd consequence. And then they say that obviously stems from the underlying problem that Tesco suggested interpretation of the party's objective intentions does not stand up to scrutiny. I want to take that point around there being an absurd consequence. I'm going to come back and look at this case in more detail in relation to different points in due course. We submit that the interpretation adopted by the learned judge had that impact.
Had what impact?
Of creating an absurd result.
So what you're citing Tesco simply for the proposition that an interpretation as an observed result is not likely to be correct.
Well, yes.
You're not suggesting the two situations are the same.
No, that's correct. But I'm going to come back and look at this, I said, in more detail in relation to a different submission. What essentially the learned judge did was insist on a high level of...
But is it a... Go on.
Sorry. Please do ask your question.
Well, the absurd consequence in this case was that the employer could basically unilaterally get out of a right which had been expressed to be permanent. But that's not any like this case. Here, the employer has done it only by agreement. Not, as it happens with the individual, but with the trade union, who is the employee's representative. Now, it looks like the trade union did something which was not in the interests of these particular individuals, though presumably they judged it was in the interest of the workforce as a whole, as part of an overall package. And that, I'm afraid, is a trade-off that quite often happens in collective bargaining. It's not absurd. It's hard on the individuals whose rights have been discounted in favour of the greater good. But that's what happens when you sign up to have a union to negotiate for you.
My Lord, I think the point that I wish to make is slightly different to that, which is around the finding in relation to the consequences, which is set out of his conclusions, which is set out at paragraph 250.
Sorry, I was premature. I thought you were making a submission that this was absurd.
No, I'm making a narrower submission than that.
So sorry. Okay.
So, you'll see why I'm referring to the because I hopefully...
We can put Tesco away, can we?
Yes, you can put that away. And it's page 148 of the core bundle. There's another point I'm going to address in relation to this paragraph 250, but that's to do with crystallisation. I'm going to come back to that. But this is a point around outcome and absurd result. It's essentially, the learned judge, I submit, falls into a similar error in relation to what he says in relation to this. So he says there's a fundamental difference between those who are funded by the insurance policy and those who are funded by TUI. For the former group, I'm sorry, it's about halfway down the page.
Thank you.
For the former group, the insured risk has already materialised. That's the crystallisation point that I'm going to come back to. That is, the pilot who's covered by the policy has become sick is entitled to benefit within the terms of the policy paid by the insurer to TUI. The protection therefore comes not only from the statement in paragraph 5.1, but from the fact that the benefit is already being paid and will continue until eligibility ceases. Whilst technically an employer who receives an insured benefit on behalf of an employee, which is then absorbed into the payroll, may choose to pay less than he received from a third party, the industrial and potentially legal consequences of such actions would be significant. The interpretation on that point we submit is what the judge is effectively saying is that TUI and his interpretation can change rights for those in-claim pilots who are under 60. That's obviously a natural consequence. They can, as long as they collectively bargain, they can change any in-claim pilot's rights under the handbooks. But he says, well, for those who are under 60, because they've got insurance, that wouldn't happen because there'd be legal and industrial consequences. And that is exactly the mischief that is identified in Tesco. So that's
It's a different mischief, isn't it?
It is a different mischief. But it's the same type of mischief, which is thinking, well, we're going to come to a result which has these very serious consequences to individuals, and okay, because they could do something potentially by industrial action or legal action, it's okay. And I submit that's what I'm drawing out of Tesco in relation to this particular submission.
But just looking at the looking testo, just looking at the submission on its own merits, so I just want to make sure I understand what he's thinking about. He's saying, well, the main point he's making is, well, there's no protection to, there's no problem until you're 60 because they're insured. And he's then saying, well, you might say there still is a problem because theoretically, even for the insured payments, they could choose simply not to pay the amount and therefore presumably not claim from the insurer. But that is very theoretical, and I would have thought actually wrong in law, because I thought the employee could insist on them claiming for the insurer.
Or TUI could obtain payments through the insurer and not pass that on, which is, I think, where he talked about there being industrial.
Well, then you almost certainly have some sort of trust right to it, wouldn't you?
Well, potentially, but it shows the problematic. Problems.
But why are we concerned with the pre-60 group anyway? I don't know in what context the judge is referring to it there. Over 60, we're concerned with the over 60 group.
My lord, that's right. But the consequence of the interpretation, which is that the benefits could be changed through collective bargaining, means that the benefits of under 60s could also be changed. That's a consequence of the interpretation, and that's the point I'm making here. And I'm going to come back and deal with that.
Is that your submission is that the judge's interpretation that in claim under 6-year-olds benefits can be changed. You're saying that he cannot diminish the consequences of that by saying it wouldn't happen anyway because it would be industrially and legally inapt.
Yes, that's correct. That's what I'm submitting.
But that doesn't diminish the, in your submission, the consequence of the fundamental consequence or impact of his interpretation.
Yes, it's a consequence of it, and a reason why we submit that interpretation is wrong. If I may now just...
Sorry, just going back, because this is based on his understanding that this is your point about crystallisation, but it's that the insured risk has already materialised, and so the pilot will remain covered and entitled to benefits. And so the judge sees that his protection coming not only from 5.1, but also the fact that the insured risk has crystallised, so the insurer is under an obligation to meet the benefit claim.
Yes, and my lord, in relation to crystallisation of those under 60, we don't dispute that the judge is right. It is the insured event is the point of incapacity, and that happens prior to benefits being paid out, obviously. This is a point I'm going to deal with in due course, but where we submit the judge erred was by drawing a distinction between those who have insurance behind them and those that don't. I don't want to address on that submission at this point, so I want to come back to that if I may.
But it also, in order to fully work this point out, it is necessary to make sense of 5.5, which is part. Because if they did, in fact, have a right under the third-party contract, they could sue the insurer anyway. Even if
the under 60s could, yes, my lord.
Yes, even if TUI chose if TUI chose not to pay them and not to make a claim, they could say, well, they can sue under the policy. So unless 5.5 is a statement that they can't do that, the problem would never arise.
Yes, my lord, and we'll come back to you on that, but as I understand it, the way the first sentence of paragraph 5.5 is written suggests that they're trying to ensure there aren't legal rights, and the second sentence says there are if there's something happens to TUI, essentially. But we'll look at that.
Well, we're just on it now. Yeah. I just want to flag up that's why it's important, as far as this point's important at all, quite important to know what the legal rights in that situation would be. Anyway, sorry.
No, thank you. I'm just going to come back to the reference to AMDOCs, which I went through in a little bit of detail. So in paragraph 12, we deal with a right skeleton argument, which is actually called on paragraph 20. You don't necessarily need to turn it up, sorry, page 20. We say, if the contracting parties wish to qualify the contractual provision, express wording to the effect that collective bargaining could vary PHI benefit those in claims to be expected. The fact that it's not there, we say, it tells in favour of that appellants, but was wrongly considered by the learned judge to tell against them. Essentially, if TUI were going to retain the right to change benefits in the way that they have done, we submit that should have been expressly stated, reminding ourselves that this is a plain language handbook for pilots to understand their rights.
You say to change rights, you mean to negotiate an agreement with the pilots' representatives?
Yes, and then to go through the collective bargaining mechanisms.
But your submission is only in respect of crystallised benefits.
Yes, and all in-claim pilots have got crystallised benefits. I'm going to submit in due course.
You just said your submission was change benefits, but your submit it's not that broad.
No, you're right. You're quite right picking me up. I mean in-claim pilots.
Yeah.
So our submission is simply that if TUI wish to retain a restriction to the term any change by way of using the collective bargaining mechanisms, then that should have been expressly stated. And that's essentially the principles that were taken from AMDOCs, which is if you're going to be cutting down a right, that should be stated expressly. And again, I've sought to put together a form of words that might do that, which would be understandable to the individuals. And I've done this just to show the difficulties with the judge's interpretation, which is going to the proposition that restriction should be expressly written. It would be something along the lines of, benefit already being paid at the date of any change will continue, and will therefore not...
Hang on, if you want us to write this down, you have to go...
Apologies. I picked up the second sentence.
Yeah.
And then...
So,
Second sentence of paragraph...
Paragraph 5.1.
So, where's the point at which you're into?
So,
I can do dot until...
Yeah. So I just cross out such in the last part of any such change. And then I've written this, and again, I'm sure you'd have a far better way of writing it, but this is what I propose. Except where the change is introduced through the collective bargaining process.
Hang on.
Except where the change is introduced through the collective bargaining process, whereby the benefit may be varied or discontinued. And that is obviously, I submit, not there, and that is one of the reasons, or another reason why the phrase any change necessarily incorporates change by collective bargaining. I spent quite some time looking at the particular part of paragraph 5.1, so if I may move on to context. And I'm going to do that in 3 stages. First of all, by looking at the paragraph itself. Secondly, by looking at the 2015 handbook in the round. And then thirdly, by looking at the background into which the handbook was introduced. And the key parts which I'm looking at start in terms of the judgment, really starts at paragraph 249 to 252, and then 261, 262, and 263. But the general point is that when you read those paragraphs, it doesn't seem that the judge has set the words in paragraph 5.1 within the context that they should be derived from. And I submit that's important because it's perhaps one of the reasons we submit why he fell into error. I first deal with paragraph 5.1 on this point in paragraph 13 of the skeleton argument, where we look at the context of the paragraph itself. And first of all, just starting off, which is, and again, I'm looking at page 59 of the supplemental bundle.
Sorry, hold on a second.
Sorry, I was going to 13 of the skeleton.
That's just to reference you where I am in terms of
I see.
you don't need to turn up that apology.
Okay. So where are we going?
I'm in the supplemental bundle, page 59.
Oh, okay, thank you.
I'm still looking at the paragraph now.
Yes.
So the first point is the question that's being asked. It's important to understand what the paragraph is answering in order to put it in its context. And the question is, can the plan be altered or discontinued? It's an open-textured question. It is not, can the plan be unilaterally altered or discontinued, for instance, or can the plan be altered or discontinued by the company? It's more open than that. The first part of the paragraph, which starts obviously your company, answers the right about what the company can do in relation to change. So the employer reserves the right to modify, suspend or discontinue.
Well, strictly speaking, it's the company and the plan manager.
Yes, that's
so it's
correct.
describing what those two parties to the plan can do with the plan.
Yes, and just, we haven't especially gone to this, but the plan manager is defined, and it's TUI Travel Healthcare Limited. So that's absolutely right. So they express the hope that they're going to continue the plan indefinitely. So that's the first point they say. So that's important because it puts it in context. But then they reserve the right, in certain conditions, future conditions, in their opinion, warrant such action. And that's subject to employee consultation as appropriate. The next sentence we've already looked at in detail, but just to pick up at one point, which is, it's in direct antithesis of the word discontinue. It states will continue. And that, I submit, is unqualified by reference to that first sentence. So the way we say the structure of this is that it permits discontinuation of the plan generally. And that necessarily follows where somebody's not in claim. They haven't had their benefits crystallised. So it follows that it's something that can be amended. The difference we say in the second sentence is that it deals with those crystallised rights of in-claim pilots. And that's a fundamental difference. And that's why we say, firstly, you look at this separately, but secondly, it is applicable only to in-claim pilots. We say it's effectively ring-fencing the benefits for those that are in payment. And that's from all subsequent changes up to and including discontinuation. And of course, TUI in drafting this obviously understood that there's a difference between those not in claim and those in claim. And that's how it's being stated, benefits already being paid. So they understood that there's a difference between different groups of pilots, those who claim, those not. Picking up then on the broader issue of the handbook, and again, you don't need to turn this up, but I deal with it at paragraph 15 of the skeleton. I've taken you through this already, but the references to permanent health insurance through TUI, and you can see that both in the name given to it, but also in section 1 and in the definition of plan. That's important because, again, going back to the way that this would be looked at by a reasonable person, it's a permanent benefit. It's not something that should or could be easily cut down, certainly not once you're in claim. And that's consistent with the aim of the handbook, which is set out in paragraph 1, around increasing security of those who are out of work, where state benefits are not guaranteed, to provide financial protection to those long-term sick. Effectively, TUI are acting in a way is to...
No, not TUI, TUI and the union.
TUI, sorry, no, I'm talking about the handbook at this point.
I see.
So TUI effectively are providing a form of insurance themselves for those unable to work by providing that protection. Financial payments during that incapacitated period. I want to turn to paragraph 3, and there's 3 specific points that I want to draw out. So paragraph 3.1 is page 55. And just to remind you that this is a contractual term, that's what the learned judge found. And sorry, and just so you have that again in mind, he makes that finding at page, paragraph 246, page 146 of the core bundle, and 309, page 164 of the core bundle.
What do we get from those paragraphs?
Just simply that 3.1 is contractual. You don't need to
you've said that already.
Yes, but that, I just want to cross-reference you. Again, turning back to the wording, and it's the first paragraph, 3rd sentence, where it talks about when the benefit will end, and it says it's payable until the earlier of the following, and it sets 4 specific events that would end the benefit. What it doesn't state is that that benefit, once you're crystallised, would end by collective bargaining, in particular, but by change at all. Going back again to that sort of amdocs, if you're going to try to cut down something, you should say expressly, it doesn't state that here. What it does set out is consistent, we submit, with the interpretation adopted by the appellants, that the reference to any change is broad, because if it was not going to be that, you'd expect something to have been set out, I submit here. The next point I want to just refer back to is the definition of plan, which is at page 61. That paragraph 5.1 specifically refers to plan, and so it's important just to bear in mind again within the context what that says. It refers again to permanent health insurance, and it refers to it being established to provide you with regular payments if you are unable to continue working for your company in your current capacity or any alternative capacity for an extended period. So that picks up on this idea of permanence and being paid when you're unable to work because of incapacity. And the final point in relation to the handbook that I'd like to make is just the general context of paragraph 5.1 within the handbook. Looking at, in the round, at what the purpose of the handbook is, which I've taken you through, I submit that it demonstrates there should be a broad interpretation, or an interpretation that's consistent with what the appellants say, i.e. it shouldn't be cut down in the way that the learned judge did by this idea of collective bargaining and trumping it. And the ability to change the protection of those already incapacitated and in claim does fly, I submit, in the face of the way that the intent of the scheme is expressed within the handbook. This is about providing long-term benefits to those that are incapacitated. Final point, just picking up on the wider context of the handbook. The handbook is the only means by which individuals could see what they understood their rights were. It wasn't subject to collective bargaining, it was written by TUI, therefore one would expect that if they wished to carve out those sorts of exceptions to allow them to collectively bargain, that would have been expressly stated. Also, there'd be no previous attempt to cut down the benefit of those in claim by changing the entitlement of PHI or the benefits amount, which is consistent with it being a permanent structure. And then finally, just picking up on commercial context and common sense. It's an important provision for pilots. Pilots are subject to rigorous medical examinations on an annual basis. As a particular cohort of workers, they are therefore subject to potential ill health or incapacity within the terms of the handbook because of the strict requirements for pilots, unsurprisingly. The handbook provided them against serious financial hardship if the eventuality came about that they were unwell and couldn't carry on with their vocational career due to ill health. And it's part of the package of benefits provided by TUI for these key employees. Undoubtedly, it helps recruit pilots. And it's something that was provided to pilots since at least 1974.
There's an important other element, isn't there, that it is important that these benefits are present and generous to avoid any incentive on pilots to conceal ill health. I saw that point made by the judge.
Yes, my lord, that's obviously correct too.
Yes.
I'm going to deal with one more point for the lunch break, if I may. This is just around, I think we've already touched upon it, and maybe I just need to make a short point, which is just around that use of the language in the memorandum B that we looked at the beginning, which is the new PIP agreement, where they reference PHI. It's, as I said, it's an odd one. The wording is odd, but it does. It does say something.
Is this the in accordance?
Yes, in accordance with. So it's paragraph 3.27. Just so you've got that next. It's page 204 of the supplementary bundle. There is recognition, I submit, there about the power of the second sentence of paragraph 5.1. There would be no need to say that if 5.1 didn't mean something, and we submit that it's plainly reference to the fact that benefits have been ring-fenced. So finally, just in terms of this final conclusion, and then I'm going to deal with some other points, the judge has failed to place 5.1 in context when he was looking at his interpretation. He didn't draw out the wider aims of the handbook. He didn't place the paragraph in the context of the question asked that it answered, and he didn't draw out the essence of that. And had he done so, I submit he would arrive at the proper interpretation, which is the one that I've taken through about what any change actually means. My lords, I'm going to just, I'm just aware of the time. Unless there's anything I can answer about in relation to the literal contextual questions of interpretation, I'm going to move on to just deal with some points which will be clear important to the general understanding of where the judge ended up.
Yes.
I'm grateful. I'm still on paragraph 5.1. And I'd like to just pick up on the term used in that paragraph 5.1, which we haven't addressed particularly yet, but is in the third line of page 59, where it's the sentence, or sorry, the phrase is subject to employee consultation as appropriate. So TUI refer to employee consultation as being something that would have to take place if they were going to modify, suspend or discontinue the plan. Judge, I didn't particularly spend much time on that, but it is, again, I submit, important to consider, and I deal this at paragraph 17 of the skeleton argument. So firstly, obviously, by including that phrase employee consultation, that was expressly incorporated into paragraph 5.1, and TUI considered that was something that should be included as limiting their right, whatever they understood employee consultation to mean. So it fetters that broad ability to otherwise modify, suspend or discontinue. Similarly, one might think that if there was going to be a subject to or point made in relation to the benefit where being paid, then you'd expect that to be set out in the second sentence. So you'd expect there'd be some form of mirror of that. So again, it points to, I say, my understanding that if you were going to cut down the broad we submit right in the second sentence, you'd expect that to be expressly stated. And I've given you my form of words of what that would look like. It's the third example that I gave you. Instead, the absence of a wording, I submit, reflects that true position, that it was intended to protect benefits regardless of how the change was proposed. Paragraph 17.2, there's an issue we submit as to whether or not employee consultation could mean, or does mean, in fact, collective bargaining. It's not something particularly addressed by the judge, and it may be a little bit of a red herring. You'll have seen reference to Costal and the statutory framework is in the authorities bundle. The question is, of course, these are contractual terms and conditions, whether or not, in order to change them, the TUI would have always had to collectively bargain them, which means that the reference to employee consultation must mean, or could mean, collective bargaining. And if that's right, then the reference of any change in the way that the learned judge adopted would also include collective bargaining. It's an alternative way of looking at this. In any event, the judge doesn't spend much time on the consultation, but I submit that does throw up some questions and deal with those, as I said, in paragraph 17. Of course, what happens in practice is that when these rights are negotiated with TUI, between TUI and Balfour, they say that there is no requirement to consult with their employees. In fact, they don't do so, despite...
Well, that would be, if their analysis was correct, that would be what you'd expect. If you're dealing with the union, you can't also consult with the individuals. You expect the union to represent the individual's interests. It would just muddle up the whole negotiation if you
absolutely,
do both.
Yes.
So I'm not sure this really goes anywhere.
Well, I think the point being made is that yes, it's a bit of a muddle, and
well, it's not a muddle if the defendants are right. If the defendants are right, then you would want to consult with the individuals if you were going to do anything unilaterally. Consult in industrial relations terms is different from negotiate. But good practice would mean if you were going to take away their rights in circumstances where you'd retained the right to do so unilaterally, you'd certainly want to consult with them.
but I think.
But that's totally consistent, therefore, with the defendant's case, isn't it?
Well, my lord, I think it's also consistent with our position.
Well, exactly. That's why the whole thing doesn't really go anywhere.
Yes, my lord, I'll move. I wanted to address it because it's there, and we do so at paragraph 17. The next point I want to, my lord, I wonder if this is a point to pause. I'm going to deal with crystallisation next, and that's a slightly longer point. There's two cases to take you to.
Might as well stop now then. Are you on track for your time estimate at least?
Yes, I believe so.
Good. Okay, we'll start again at 2 o'clock.
What round favourable?